Welcome, everyone, and good afternoon. We're delighted that you could join us today for this milestone occasion, the investiture of Professor Jacqueline Ross as the Prentice H. Marshall Professor of Law. Let me begin by making special mention of Jackie's family who are joining us here today. Her husband, Richard, also on the faculty here. Their son from Chicago, Benjamin. Their daughter, Miriam, who's in from New Haven. And Jackie's brother, Leo Katz. If you're experiencing a little bit of deja vu, it's because yesterday we were all here celebrating Richard's investiture. You know, before I came here to Illinois 3 years ago, I wasn't that familiar with the concept, much less the tradition of the investiture, which is a wonderful way academia has to acknowledge and honor faculty members who over the course of their careers have attained the highest levels of academic achievement in research, teaching, and service. I think it was then Dean Heidi Hurd, who's here in the audience today, who was responsible for really kind of shaping and building the tradition we have here at Illinois of these wonderful investiture events, and I thank her for that and much more. As some of you heard me say before, in addition to celebrating our incredibly accomplished, deserving faculty, like Jackie, investitures are also about honoring the donors whose gifts, whose vision, whose generosity, whose foresight make discovery itself possible. The Prentice H. Marshall Professor of Law was established through gifts from the law firm of Jenner & Block, as well as from Dan Considine, class of 70, and William Conlin, also class of 70, in honor of College of Law alum and College of Law faculty member Prentice Marshall. Marshall was born and raised in Oak Park, Illinois. After high school, he served 2 years in the Navy. Under the GI Bill, he studied here at the University of Illinois, earning his undergraduate degree in 1949 and then his law degree 2 years later in 1951. After law school, he clerked for a federal judge, and then in 1953 he joined what is today Jenner & Block, but what at that time was Johnston, Thompson, Raymond, and Mayer. He was a partner there from 1961 to 67, helping to establish the highly regarded pro bono practice and program that Jenner is known for. In 1967, he joined the College of Law faculty and taught evidence, civil procedure, and trial advocacy. He is credited with developing the college's trial ad program as it exists today, using practicing trial lawyers, as well as sitting judges to help teach in addition to the full-time faculty. During his time here at the college, Prentice Marshall influenced the legal careers of literally hundreds of future leaders of the legal profession. He trained hundreds of very successful litigators, and his expertise in trial ad gained national attention when he became the founding director of NIDA, the National Institute for Trial Advocacy, something I didn't know until very recently. Marshall subsequently served as a federal district judge in Chicago, the Northern District of Illinois, from 1973 to 1996. He was one of the few Democrats to be nominated for a federal judgeship by Republican President Richard Nixon. That happened at an earlier time. He retired in 1996, but served as a mediator and arbitrator for the Chicago law firm of Cotstrillos, Teehee, and Stryker after he left the bench. You know, when I was in law school, toward the tail end of Prentice Marshall's judgeship in Chicago, everybody, you know, I knew wanted to clerk for a very small number of Court of Appeals judges, the feeders, the people whose clerks went on to the Supreme Court the next year, the Abner Mikvahs, the Bill Norrises, the Doug Ginsburgs, the D.H. Ginsburgs on the D.C. Circuit. But there were two, and I think there were only two district court judges that kind of had that stature, in the same way that, you know, maybe Learned Hand has the same stature as a Supreme Court justice, even though he never was on the court. And they were incredibly sought after as mentors and clerkships, and they were Lou Pollack in Philadelphia, who was the former dean of Yale and Penn's law schools, and Prentice Marshall. And so, although I never met Judge Marshall, I kind of revered him from afar and over time. When his family contacted us this last year about donating a piece of furniture here to the College of Law, I was very thrilled. Usually, I get excited when someone says they want to donate a chair. But they wanted to donate a desk. And I said, we'll take it. So we have Prentice Marshall's desk. We hope to display it in the rare book room, but it's very big, and we're not sure how we can get it in there without taking it apart in a problematic way. So right now it's in the main floor of the library, but it'll have a permanent home soon. We are delighted as well this afternoon to be joined by a very distinguished campus leader, Dr. Paul Alger, Associate Chancellor and Vice Provost for Budget and Resource Planning. As Vice Provost, Paul provides strategic guidance and budget planning and allocation specialization advice to the Chancellor and to the Provost. He is the key person in all matters budget. I mean, it's really that simple. He has been on the University of Illinois faculty since 1995, specializing in finance and accountancy in the College of ACES. And prior to joining the office of the provost and serving as a full-time administrator, something some days I'm sure he laments, he was the head of the Department of Agricultural and Consumer Economics. So please join me in welcoming Dr. Paul Alger.
Thank you, Vic. And before we get into the talks, it's actually quite pleasant coming from the College of Aces and seeing all the ag pictures that you have in here. I'm not sure what the history of that is, but anyway, I'm very pleased to be able to do this on behalf of the Chancellor and the Provost. The Provost is in China today and asked me to sort of say just a few remarks, mainly how important these are to campus and how significant they are to campus. And it's really a privilege to be part of this. And as a head and I think as a dean, I think the three most important things we do are hire good people, promote good people, and reward and acknowledge good people. And it doesn't happen without hiring them in the first place, so I applaud the college for bringing somebody in here and nurturing in that as well. So I think these are things that we do really well. I also like doing this for the College of Law. I've done Sue Thomas was here. I was fortunate to be able to attend her investiture because I learn something every time because we get to hear a lecture, we get to hear some really interesting things, and some of the other colleges. Every college does it a little bit differently, and this one we get to learn and Vic also is someone who teaches me a lot in my role as well. So he teaches me with the things that are going on. So anyway, I know as days as a professor here how hard how many hours that you had to do without your family to get to this level, how hard work this is to achieve this level at such a renowned institution like ours. When we think about the reputation that we have, not only at the College of Law, but at the university to achieve chair status is truly remarkable. I don't know, you're going to have investitures for your desk? I'd like to attend that one if you can. Anyway, Professor Ross really is changing legal education as she is a respected scholar and the writer of several foundational textbooks used in universities across the globe. Her perspective on evidence in criminal law and procedure are helping our next generation of legal minds. Today we celebrate that work and scholarship. And again, one of the things that I want to talk about, especially coming from the budget side, how important these investitures are, how important these extra resources, it really helps. It signals not only, it's a financial benefit, but it signals to the world about how people are willing to invest permanent resources into things like this. So these are really important for us. It's important to be able to acknowledge this when I've gone to other colleges and actually talked to other people from other universities. Sometimes the other universities don't sit back and do that. They're learning. They would come here as guest speakers and so forth, and they don't do it like that at their campus. So I think taking the time to do this, taking the resources to do this, I think is really something that we value here at the university. And again, these gifts are really investments in people, in ideas, and human potential. They are critical to able to recruit and retain faculty. And we're so grateful to individuals to help support this. And Professor Ross, we know you have other opportunities to go other places, and we're really grateful that you've chosen to come here and to stay here. Again, congratulations. It's a really momentous milestone as a faculty member, and we look forward to celebrating these achievements. Thank you.
Thank you, Paul, and thank you for kind of setting the stage for my more formal introduction of Professor Ross. A renowned thinker in the fields of criminal law, criminal procedure, and evidence, Jacqueline Ross has amassed an incredibly impressive scholarly record. She is the co-editor of Comparative Criminal Procedure and co-editor of Comparing the Democratic Governance of Police Intelligence, New Models of Participation and Expertise in the United States in Europe. As well, she's the co-author of the Manuel d'intelligence de secours public pour la police nationale, which is the required textbook teaching police intelligence to French commissioners at l'École Normale Supérieure du Police. She currently is under contract with Cambridge University to write a monograph called Undercover Under Scrutiny, a comparative look at covert policing in the United States, Germany, Italy, and France. The book will offer the first sustained inquiry into how these countries conceptualize and regulate covert operations, contrasting legal actors' assumptions, ambitions, fears, and habitual ways of doing business, highlights what is distinctive about the systems they inhabit, and illuminates the promises and challenges of transnational cooperation. Jackie's also received a Fulbright Research Fellowship and a grant from France's Agence Nationale de Recherche to fund a new research project comparing how French and American police in particular use local security partnerships as sources of intelligence. She's published on undercover policing and local security partnerships in both journals here in America and in Europe as well, including, and this is just a sampling, the University of Chicago Law Review, the American Journal of Comparative Law, the Oxford Journal of Legal Studies, and the Annual Review of Law and the Social Sciences. Her article, Impediments to Transnational Cooperation in Undercover Operations, a comparative study of the United States and Italy, won the Edward Wise Senior Scholar Prize from the American Society of Comparative Law for the best article in comparative criminal procedure. Her article, The Place of Covert Policing in Democratic Societies, a comparative study of the United States and Germany, was also awarded the Ed Wise Senior Scholar Prize at the University of Illinois College of Law, where she received the Carol P. Hurd Award for Excellence in Faculty Scholarship in 2008. She's been a visiting professor at Columbia University, at New York University. She's co-director of the UCLA, Illinois, Princeton Comparative Law Work in Progress Workshop, and a co-organizer of the Transatlantic Seminar Series on intelligence-led policing and local security partnerships. That's a lot of stuff she's done and is doing. She received her bachelor's degree with honors from the University of Chicago. She was articles editor of the University of Chicago Law Review and graduated with honors from that law school. She then served as a clerk to the aforementioned Douglas H. Ginsburg in the U.S. Court of Appeals for the D.C. Circuit, who came to be on our moot court panel just a couple of years ago. And then she spent 9 years as an assistant U.S. attorney in Chicago and in Boston, acquiring extensive federal trial experience and arguing as well before the First and Seventh Circuit Courts of Appeals. Her colleagues praise her as, quote, a world-class scholar and truly in a league by herself, a leading world authority on comparative undercover policing, who has made significant contributions to other areas of legal scholarship as well. One said that Jackie is, quote, hands down the leading American criminal procedure comparativist and one of the shining lights in her field. Another remarked, in the realms of comparative policing and undercover policing, I know of no one who has done more and more innovative work than Professor Ross. In my mind, these are her fields. As a comparative scholar, she might take special pride in how well regarded her work is on both sides of the Atlantic. As one peer put it, certainly every American criminal law comparativist knows and celebrates her studies of undercover police work in Germany, Italy, and France, but she's equally well known and admired in those places. Jackie is not someone who has let her zeal for scholarship sap time and energy away from her teaching. Her students characterize her as, quote, incredibly knowledgeable, very approachable, extremely smart and friendly, and a brilliant professor. One explained that she does a fantastic job at breaking down concepts and displays a respectful, professional attitude. What I found as I sifted through the piles of praise from students were two themes that recurred time and again. One was the depth of her knowledge about the topics she covers, and the other, commendably, was how her passion shines through her presentation. When you know your stuff and you care about it, that's a pretty powerful and inspirational combination for a teacher. A respected colleague, a distinguished scholar, and an admired and highly effective teacher, Professor Jacqueline Ross, it's my privilege today to recognize your many accomplishments and confer upon you this honor that you so clearly deserve. Thank you so much.
Thank you so much, Dean Amar, and thank you so much, Dr. Alger, for these very generous introductions. I'm very honored to be appointed to an endowed professorship named for Judge Prentice H. Marshall, who was one of the most distinguished district judges in the country, and in fact was a legend when I was at the U.S. Attorney's Office. It was a name that everybody spoke with awe. So when I heard that this was the professorship that I was going to be named to, I was floored, and I'm deeply honored and deeply grateful to Don Considine, William Conlon, and to Jenner and Block for generously endowing this professorship. Thank you also to Carrie Mae Burich and to Carrie Turner for your wonderful preparations for this event. And I'm very grateful to my terrific assistant, Mary Parsons, for all your hard work and your uncanny skill at planning ahead and anticipating always what needs to be done. Thank you. I'm very moved that my brother Leo Katz flew out here to join Richard and me for these wonderful back-to-back events. Leo is the Frank Carano Professor of Criminal Law at the University of Pennsylvania, and his brilliant book, Bad Acts and Guilty Minds, is what inspired me to become a prosecutor and later to write about criminal law. I am so grateful to have you as my brother and as my partner in crime. Our parents are no longer with us, but I think they would have been so happy to see us together here for this celebration. They always championed and encouraged and inspired us, and I like to think that they are with us in spirit. It is a special treat that my children, Benjamin and Miriam, came back from college for our investitures and that they are here to celebrate with us. The children have literally grown up with my research project on undercover policing. They cheerfully endured bedtime stories about koala bears who went undercover as stuffed animals. And when they were older, they actually helped with the research. Benjamin went along on several interviews with former undercover agents, and he asked great questions. He also found some of them for me by locating some of the more remarkable memoirs written about undercover exploits. Miriam, in turn, keeps me apprised of the latest neurophysiology research about risk-taking and crime, and she never fails to ask me for the highlights of every interview. Finally, a special word of thanks to my husband, Richard Ross, whose investiture was yesterday. Thank you for not flinching for even a moment when I told you some 19 years ago that I was thinking of leaving my good, secure job at the U.S. Attorney's Office for a then entirely speculative future in legal academia. Thank you for your enthusiasm and your encouragement, for being so certain that I could do it, and thank you for making my dreams your own. I love you so much. My talk today draws on my research on undercover policing and on the book that I'm working on for Cambridge University Press. The book compares the ways in which 4 different legal systems fret about and try to control undercover investigations. The book will be called Undercover Under Scrutiny, a comparative look at covert policing in the United States, Italy, Germany, and France. The way legal systems regulate undercover policing expresses each country's most pressing fears of a symbiotic relationship between power and crime, a fear, that is, of the state's illicit influence on those it purports to regulate or condemn. Though every society shares this concern, every society regulates the undercover agent's influence on these, and in particular his influence on the target environment, somewhat differently, and regulates it in ways that reflect the particular abuses of power that regulators in that society worry about most. To understand the way each country regulates undercover tactics is to identify the pathologies of influence that are uppermost in the minds of the rule makers in each legal system. If we were to focus on transatlantic differences between American and European regulation of undercover investigations, we would notice the importance of the warrant requirement as a mechanism for controlling undercover policing in Europe, and we would notice the complete absence of any such requirement in the United States. In the US, we're familiar with warrant requirements because wiretaps, along with other kinds of searches and seizures, all require advanced judicial authorization by a neutral magistrate based on a showing of probable cause. But unlike Germany, Italy, and France, we've never required the police to get a judicial warrant to start an undercover investigation. If we focused only on the transatlantic comparison, we would also notice that Europe has undergone to us, entirely mysterious regulatory trajectory that in no way mirrors our own system of regulating undercover operations. This is a historical trajectory that for a long time consigned undercover operations to a kind of legal limbo in which it was entirely unresolved whether such investigations were legal or actually criminal. The European warrant system that I just mentioned is actually a product of the 1990s. It's recent. Before that, Italy, France, and Germany all regulated undercover operations through the threat of criminal sanctions, viewing undercover investigations as a kind of quasi-criminal mimicry of criminal conduct and of the crimes that the police were investigating. If undercover agents transported drugs from a seller to a buyer, for example, they risked going to jail for illegally transporting narcotics, even if their only purpose was to document the criminal activity of their targets. After 1990, France, Italy, and Germany all enacted laws legalizing undercover investigations, but at the same time requiring the police to obtain a judicial warrant in advance, and the new statutes restrict undercover policing to the investigation of only the most serious crimes, while the US imposes absolutely no subject matter limitation at all on the crimes that can be investigated undercover. So the great novelty of the European warrant requirement was that it regulated undercover agents not as ordinary citizens who risked going to jail if they became too closely involved with the crimes that they investigated. No, instead, the warrant requirement treated undercover agents as role agents, that is, as government investigators, who were subject to government-specific rules. This gave them power and a certain degree of legal protection, but it also subjected them for the first time to claims that their actions violated the fundamental civil liberties of the people or targets they investigated. So long as the legal system treated undercover tactics simply as a government-sponsored form of criminal activity akin to the Watergate break-in, such tactics had no more effect on fundamental rights than any other break-in or any other burglary. Only once undercover agents came to be regulated as government actors could their activities have any impact on rights. This is because civil liberties exist first and foremost in relation to governments, not in relation to other private actors such as criminals. By contrast, American undercover operations had no counterpart to any of this. Not only has there never been any warrant requirement in the United States for undercover operations, but there is no statute regulating what crimes you can investigate undercover, and undercover agents have never been threatened with criminal sanctions simply for pretending to be criminals. American undercover investigations have rarely been challenged successfully as violations of civil liberties, such as privacy interests or due process rights, or the privilege against compelled self-incrimination. In contrast to the European Court of Human Rights, our Supreme Court has held that undercover tactics infringe no protected interest in privacy. The only transatlantic point of commonality is the entrapment doctrine, which prohibits government agents from unduly tempting someone to commit a crime they otherwise would not have considered committing. But even that turns out to mean very different things in each system. If we turn, however, away from the transatlantic comparison to the four-country comparison, this comparison becomes somewhat less clear-cut, because it turns out that the warrant requirement actually means very different things in each legal system, and that each system uses it to protect very different interests. I will say something about what those different interests are, and then I will come back to the puzzle about why we regulate undercover policing so differently from everyone else. The regulation of undercover policing is a kind of Rorschach test of each society's particular fears for the rule of law. For that reason, the warrant requirement accomplishes something rather different, and I'm going to take the countries one by one. And taking Italy first, we're going to see that in Italy, the warrant requirement is intimately bound up with what's called the principle of compulsory prosecution. Prosecutors there are subject to a requirement that they charge all criminal cases for which there is a threshold level of evidence. Judges can actually compel prosecutors to prosecute someone that the judges believe should be prosecuted if there is sufficient evidence to warrant it. And the obligation extends to the police as well. They're obligated to make arrests for serious offenses that are committed in their presence, that are committed in flagrante, and they have to do so at the first possible moment. Not only that, they're also obligated to seize all contraband, drugs, guns, any other contraband that stems from the commission of a serious crime, and to do so at the first possible opportunity. Now, this would actually make it impossible, if followed, to conduct any kind of undercover investigation without intervening to make an arrest and make a seizure as soon as the police observe somebody bringing drugs into the country or transporting them, unless a prosecutor issues a warrant, and a warrant authorizing the police to delay the arrest of the targets and to delay the seizure of the drugs until the end of the investigation. This form of control over when the police intervene to secure drugs or other contraband or to arrest their targets is a safeguard against corruption by the police, who could otherwise disguise illegal activity as part of an undercover investigation. So technically, actually, the Italian warrant requirement does not even authorize the undercover investigation itself. It simply allows the Italian police to hold off on making arrests and seizing drugs or guns or other contraband without facing criminal charges themselves for dereliction of duty. So it's simply a way of creating a discretion to wait, of buying more time for the investigators. In France, the police do need written authorization from a prosecutor or an investigative judge, note not from a neutral magistrate, before initiating an undercover operation. But the French warrant requirement is largely a mechanism for centralizing the control of undercover investigations in a single investigative unit. Why? Well, this ensures top-level control over undercover investigations, which otherwise can easily get out of hand. And it's done also to avoid the kind of interagency rivalries that saw police arresting rival undercover agents in the customs service in the days before the rules of permissible undercover conduct were actually spelled out. The law accomplishes this avoidance of interagency conflict, the centralization within one unit, the top-level hierarchical control. It accomplishes this because it now requires all undercover agents to be trained, certified, and supervised by the one central undercover office. This makes it all but impossible for any other police unit to run its own undercover operations, since their undercover agents would lack the necessary certification. And since the informants that they employ undercover would lack any of the legal immunities that are strictly reserved for undercover agents. French competition between police and customs was itself an artifact of European integration. With the fall of Europe's internal borders, the customs service needed something new to do, and undercover drug investigations were supposed to supply them with a new mission. Well, we'll see that something similar is going on in Germany, but it wasn't the customs service and the police who competed, it was the intelligence services and the police. In Germany, the warrant requirement enforced heightened privacy concerns for deep cover operations and addressed fears that undercover operations might erode the constitutionally mandated principle of separation between police and intelligence agencies, since undercover operations look a lot like what domestic intelligence agencies do. The end of the Cold War had led to competition between intelligence agencies and police over who would get to investigate organized crime, since Germany's intelligence agencies, like the French Customs Service, now needed a new lease of life, a new mission. And the statute staked the claim of the police to run such operations as criminal investigations and was required in order to ensure that these would not be considered intelligence operations that were beyond the constitutional mandate of the police. The warrant requirement in France, Germany, and Italy thus look fairly different from what we have, what we are used to in the US, and the three European warrant requirements actually look fairly different from each other. What all three of them have in common, however, is that they are all required by statute, that each country's statute restricts such tactics to only certain serious offenses, such as organized crime, the investigation of terrorism, child pornography, drug offenses, and occasionally new offenses are added to the list. And such tactics can only be used as a matter of last resort if all other tactics have been tried and failed. Whereas one thing that prosecutors and police are always taught in the United States is make sure to exhaust all of your undercover investigative opportunities before you ever try a wiretap or other kinds of coercive activities. So this common feature of European regulations brings us back to the original question we started with. Why are European undercover practices regulated so much more stringently than their American counterparts? And why did the US not experience the same trajectory from threat of criminal sanctions to the warrant requirement? Why is it that in the US you have neither the criminal sanctions nor the warrant requirement, and then what takes the place of those regulatory mechanisms? I believe that the reason for Europe's shift from regulating through criminal sanctions to the warrant requirement is a historical one, namely the long-standing association of undercover tactics in Europe with state surveillance of political opponents, in short, with tyranny, with political policing, and with intelligence agencies. In order for European undercover tactics to become an ultra-modern, elite crime-fighting tactics of special investigative units within the police, which is what they now are today, instead of a suspect intelligence agency tactic, which they were in the past, and suspect insofar as they were addressed to the surveillance of political opponents, such tactics had to be reborn, reinvented practically, to become consonant with the rule of law. And this meant enacting legislation, limiting its use to the collection of evidence and not the pursuit of intelligence, reassigning such tactics to the police, to elite detective units, from detective agencies, or from intelligence agencies, so reassigning them from the intelligence domain to the law enforcement domain, limiting the number of crimes to only the most serious ones that could be investigated, and limiting the use of informants in an undercover capacity. All of these constraints are the legacy of the association of European undercover tactics with intelligence agencies, with the abuse of power for political purposes, and with oppression. In the US, we have not had to reinvent undercover policing as distinct from intelligence work, because that is not our principal historical association with undercover policing. Both our undercover practices and our regulatory norms followed a very different trajectory because undercover policing developed in response to different moral panics about crime on the under-policed western frontier, about private infiltration of the labor movement, around vice in progressive-era cities, and later about prohibition and then the war on drugs. It is this separate history, distinct from the high policing abuses of undercover tactics by European intelligence agencies, which has shaped our practices and which has shaped our legal norms. In particular, the relative lack of regulation of undercover tactics, the lack of a threat of criminal sanctions, the lack of a warrant requirement, the lack of statutory regulation, all these are tied to the unique history and origin of undercover tactics in the U.S. as a grassroots private sector self-help remedy that was developed to compensate for the absence of a powerful and professional police in the rural and western areas of the United States. Undercover policing turns out to have been a technique that the state itself absorbed from the private sector without ever fully displacing it. The American reaction to what was perceived as continental tyranny was to forswear the establishment of similarly intrusive state surveillance apparatuses, or of any national police force at all. This restraint helped create an enforcement vacuum for the private sector to fill, especially after railroads and westward expansion fueled a growth in so-called crimes of mobility, such as theft and robbery of gold bullion and freight that circulated between the corporate headquarters of cattle speculators and mining companies on the one hand, and their far-flung holdings on the other. Jurisdictional boundaries were fluid and became insignificant to criminals, but were highly important to law enforcement. As criminals became ever more mobile, the police were not able to follow them, and the only agency that really could do so turned out to be a national detective agency, the Pinkerton National Detective Agency, which had the ability to cross jurisdictional boundaries, not only nationally, but even internationally, when there were no federal or local law enforcement agencies that could do so. The scarcity, fragmentation, and late professionalization of American police help account for the void that was filled by the private detectives like the Pinkertons, who effectively became the closest thing that the U.S. had to a national police force throughout the 19th century, so that even foreign governments that needed help investigating crimes against their own nationals would turn to the Pinkerton Detective Agency and not to the federal government or to local authorities for help. And the preferred investigative method of private detective agencies was the undercover operation. Foreign governments, large mining companies, and railroads could afford to pay for long and expensive undercover operations of the sort that private detectives like Charlie Siringo and Fred Dodge performed for Wells Fargo and for the Pinkerton detective agencies. Since undercover investigations were the preferred investigative technique of private detective agencies, they came to occupy a central role in policing as well once the public police came to absorb the methods of private detective agencies, and once private detectives took on leadership roles in urban police departments and federal law enforcement agencies. These private detectives who went into government, they brought their undercover tactics with them, and they made them a staple of American law enforcement investigation. Undercover operations then developed as a private self-help tactics by large corporations that were used to catch outlaw gangs, monitor the labor force, and to infiltrate and undermine the incipient labor movement. These tactics eventually exerted an osmotic influence on the public sector practices, not only because the police found them useful, but also because these practices were reviled by the public. That is, In response to the strike-breaking violence of the Pinkerton agencies in what was known as the Homestead Violence of 1892, the anti-Pinkerton backlash forced governments to develop their own investigative capacity in order to tame what was viewed as an out-of-control private sector tactic. So it wasn't that somehow what the private detectives did legitimated undercover policing. They convinced everybody that it was useful, but they also convinced everybody that you needed the government to clean up the practice. It was the wide range of private actors who resorted to undercover tactics that eventually normalized this investigative technique to such an extent that American law enforcement could never hope to establish a monopoly of legitimate stealth, as Germany, Italy, and France have all done. In Germany and Italy and France, you cannot have private detectives running their own undercover operations, as you still do in the United States. Undercover tactics were not just an investigative staple of the underpoliced Western frontier, but private resort to undercover tactics turned out also to be a function of urban density and the greater ease with which criminals and investigators could remain anonymous in large urban centers like Chicago and New York. Undercover tactics were spearheaded by prominent social reformers like Lillian Wald and the photographer Jacob Riis, with the support of the Tenement House Committee and the Committee of 15, made up of bankers, preachers, and other elites who hired their own undercover agents from among recent immigrants as part of a nativist backlash that sought to keep track of the leisure habits of recent immigrants in major urban centers. These undercover agents investigated prostitution, gambling, and the sale of liquor outside of approved hours. And in these large cities, undercover policing was the favored tool of moral entrepreneurs who hired these investigators to circumvent the police, since the police often had their own cozy arrangements with these private vice providers and did not treat vice enforcement as a priority. Social reformers were able to compete with the police because their undercover agents could fill out pre-formatted reports that were signed by a notary public and accepted as sworn testimony in courts of law. Since the social reformers that employed undercover investigators could conduct their own raids and make their own arrests and use their sworn affidavits as evidence, they had some independence from the police. And private undercover tactics continued to be used into the 20th century and even today as a form of social control that supplemented the exercise of police powers in many spaces in which the police were ineffective, corrupt, or both. In France, by contrast, private detectives who tried to do such things in the early 19th century very quickly found themselves prosecuted for what was called usurpation of a sovereign function. That's the monopoly of legitimate stealth at work. District attorneys in the US, too, used private detectives to investigate police corruption, and undercover tactics became the preferred methods of moral entrepreneurs of a wide variety who wanted to fight vice, as well as political reformers who wanted to fight corruption. The private and public sectors sometimes worked together. Sometimes they were parallel to each other. Sometimes one used the other, and sometimes they found themselves in conflict with each other. But these forces all used undercover tactics, and they were always in dialogue with each other. The state thus sought to imitate, to absorb, to adapt private sector tactics, to keep pace with them, and to develop its own capacity to carry out undercover investigations. But it never succeeded in acquiring this monopoly, what I call the monopoly of legitimate stealth, to contrast with the monopoly of legitimate force, which we've also heard about yesterday. What would have doomed any state effort to displace this private sector? Well, what would have doomed it were the many other cultural elites who used undercover tactics as an epistemological tool and as a cultural style to criticize working conditions, to learn from the inside what it's like to be a sweatshop worker, a shop girl, or a vagabond. Writers and journalists like Stephen Crane, Jack London, Hutchins Hapgood, and Nellie Bly all went undercover themselves and wrote about their experiences. Sociologists and journalists had themselves committed to mental asylums to see whether psychiatrists could tell the sane from the mentally ill. A team of undercover sociologists infiltrated a millennial cult, as recounted in their book, When Prophecy Fails. Going undercover across variously configured class lines and social divides continued from the late 19th century right into the 1950s as a way of bridging differences and learning about other people in a highly heterogeneous society. Immersion methods of ethnography and interpretive sociology were pioneered by undercover entrepreneurs in the Chicago School of Sociology. And in the US, going undercover eventually became a staple of modern-day investigative journalists, undercover discrimination testers, restaurant critics who don elaborate disguises to mimic the experience of ordinary restaurant goers, and even of the entertainment industry through reality shows like Undercover Boss. What Europeans think of as a form of state surveillance, as a form of trickery practiced by the powerful against the weak, is a form of participant observation that American elites continue to use as an epistemological strategy that provides outsiders with an insider's perspective across deep social divides and that can invite identification and empathy across ethnic, geographic, cultural, and class lines in one of the most diverse societies in the world. In the United States, even the punitive use of undercover tactics is by no means a peculiarity of state power, as illustrated by private anti-crime initiatives such as the TV show To Catch a Predator. The private sector continues to respond in an entrepreneurial manner to moral panics about online predators, child pornography, drugs, and new forms of vice. And undercover tactics are a favored strategy of these entrepreneurs. Accordingly, American undercover investigations were never fully trained, could never fully be tamed by government. And accordingly, in the United States, the only legislation concerning the respective division of labor between public and private detectives were the so-called anti-Pinkerton laws in the late 19th century. And these did not seek to restrain either the private sector or the government in using undercover tactics. Instead, they were simply designed to spur the government to develop its own undercover capacities by prohibiting the government from sending private detectives across state lines. That is, making it impossible for the government to outsource either coercive or deceptive functions to private detectives, as the state had done throughout the 19th century. So far from limiting government, the aim was to force the government to do its own undercover work and to develop its own capacity to displace the private sector, which the state never fully did. In Europe, by contrast, statutes did four things that the US never accomplished. Legalize undercover policing, not necessary since it was already considered legal in the US. Limit private stealth, that is to say, establish this monopoly of legitimate stealth, never attempted in the US. Build capacity in the state by creating special undercover units and a process of judicial authorization that legitimated and facilitated these investigations. And fourth, as the price of legalizing undercover operations and as the price of granting this monopoly to the state, the statute established limits on the state's use of power through judicial oversight and through the ban on using undercover operations for anything other than evidence gathering, that is, through the ban on using it purely for intelligence purposes. So the US did not need to legalize, and one of the reasons it did not need to legalize or establish a law regulating undercover policing is that it had not arrogated to itself any special investigative privileges compared to non-state actors. So not having arrogated to itself any special monopoly or any special powers compared to private sector actors, it also did not institute any special safeguards or constraints on the government. By contrast, and here we see that this is not just a general a story of American lack of regulation. By contrast, when the US passed legislation legalizing electronic wiretaps, it did so just the way France, Italy, and Germany did. That is, it prohibited private actors from wiretapping each other. It created a virtual state monopoly over electronic surveillance. It imposed, at the same time, legislative constraints designed to limit state abuse of this power. And these constraints included restrictions on the seriousness of the crimes that could be investigated through wiretaps, the proof that other less intrusive tactics had failed to yield results. These requirements were far more onerous than the constitutionally mandated warrant requirement for searches and seizures, or for other types of searches and seizures. Thus, the establishment of a virtual state monopoly over an investigative technique and the imposition of constraints on the government seem to be linked. Since undercover tactics seeped into the state from the private sector, American regulation has not been shaped by this association with tyranny and political surveillance that colored European suspicion. What did seep into the public sector, above all, seemed to be the crime-fighting and vice enforcement uses of undercover tactics, not the labor infiltration uses. And perhaps the clearest indication of the difference that it makes whether undercover tactics are associated with intelligence agencies or with crime fighting is the doctrine of entrapment itself, which in the United States arose during Prohibition as a constraint on overzealous undercover practices used against bootleggers. In France, by contrast, and in most other European countries, the problem of entrapment is simply called the problem of the agent provocateur, in a reference to the use of such tactics by intelligence agencies. America's greater acceptance of undercover tactics is not necessarily an indication then that Americans approved of these uses of undercover tactics by private detectives. But in the US, it was not the government that was seen as the source of the problem with undercover investigations. Instead, 19th century critics of private undercover abuses advocated that the government enter the domain because the government was seen not as the problem but as the solution to private sector abuses. Now, Europeans who look at our undercover policing system often ask themselves, they wonder, well, without a warrant requirement, without statutory regulation, without the threat of criminal sanctions, what is left to constrain investigative practices in the US? Well, what they sometimes miss is that American regulation nonetheless has one powerful safeguard that France, Italy, and Germany all lack. Our undercover agents testify at trial, exposing government tactics to scrutiny. French and Italian and German undercover agents rarely do, and when they testify, they do so through teleconferencing technology remotely that disguises both their face and their voice. So the confrontation of accuser and witness does not exist in the same way in the European system of regulating undercover investigations. Instead of an ex-ante review process that addresses the threshold prerequisite for running an undercover operation at all, what we have is trial in the adversarial process. The defendant's confrontation with the undercover agent on the witness stand, and the disclosures about the government's tactics that can be expected from that process. Now, these regulatory differences are a marker not only of the private sector origin of American undercover policing, as contrasted with the public sector origin in Europe, they are also a marker of the very different notions legal actors in each system have about what it takes to make undercover tactics consonant with the rule of law. In an interview I conducted with one of the two French authors of the French undercover law, the person who is a high official in the French Customs Service explained that the French purposely did not emulate the American system of regulation because, quote, in the US you don't have transparency. You have no law that notifies the police or the public or the judges what it's legal for undercover agents to do, what crimes they can investigate, and what tactics they can use. Then I interviewed one of his American counterparts, who frequently worked with European law enforcement agents. And the American investigator told me The problem cooperating with the Europeans is that their system lacks all transparency. And when I asked the official what he meant, he said, simple, our undercover agents testify, theirs never do. Where is the respect for the rule of law in that? In my book, I hope to illuminate the very different legal and historical trajectories that lie behind these views of what it takes to make undercover policing consonant with the rule of law. And I hope to make sense of the implicit assumptions that underlie the bewildered attitude with which European and American legal actors confront each other's investigative practices. Thank you very much.